Thank you very much indeed, Radical Statistics, for inviting me here today to talk on the subject of the Lucy Letby case, which is obviously making huge headlines increasingly at the moment. And as one newscaster put it, it could well end up being the story of the century. Maybe that's a bit of an exaggeration, but I think certainly it could be one of the biggest stories of the century. I thought I'd try and come up with a radical title for my talk, but the fact is that this isn't actually a radical title at all. It's very much a mainstream proposition now that, there's plenty of evidence showing that statistics did indeed help to frame Lucy Letby. This picture here you can see is of a roster chart that I think many of you may have seen that was shown to jurors, showing that there were 25 suspicious events, all of which Lucy Letby was present for. It's an example of the appalling use of statistics in criminal trials. One thing we're going to be trying to do is to get the use of these roster charts banned from criminal trials, and indeed more broadly trying to educate judges and indeed jurors about statistics. So this is me. I was in the financial industry for 25 years, doing analysis and statistics. I'm now applying that knowledge to miscarriages of justice, specifically these so-called cluster cases where you get an increase in the number of events of something. And this is quite a difficult area of statistics, maybe not for statisticians, but quite a difficult area of statistics for lay people to understand. Often these clusters are caregiver related, could be in a hospital environment or within a family, but not exclusively healthcare or caregiver related. The post office scandal was a classic cluster case where all of a sudden you had hundreds of postmasters being accused of fraud. I started blogging about this case when I read about the trial 2.5 years ago and dug up a few documents, and indeed wrote on my blog that, of course, the trial hadn't started then, but wrote that if there wasn't any hard evidence, which it turned out that there wasn't, but if there wasn't any, it's very likely that Lucy Letby was going to be wrongfully convicted. When the verdicts were announced, my blog membership rose quite sharply, and I started building a network of professionals, medics, scientists, statisticians. And indeed, if you would like to get in touch to join the network, please do. My email address was on the first slide, but it's also on the last slide. By way of background, these are the salient points, but of course, a detailed timeline would include so much more. One thing that I could have put on this slide was the awful tragic death of baby Noah Robinson in 2014. His inquest found that Countess doctors had wrongly intubated the esophagus twice, and that clear signs of that were ignored. The case in a nutshell, the case is horribly complex, but in some ways it's also very simple. It's about two groups of doctors who told stories, pointed the finger at Lucy Letby. First of all, you had the clinicians, the Countess clinicians, who noticed this association between deaths and collapses with Lucy Letby. And then along came the prosecution medical experts who diagnosed inflicted harm in relation to 25 incidents when Lucy Letby was on duty, and notably also, of course, no inflicted harm when she wasn't. Except, in fact, it turned out that there were as you'll see, there were similar incidents when she wasn't on duty. And in fact, now many doctors, and even at the time, many doctors have found no evidence of inflicted harm. There were 6 post-mortems at the time. 5 of them found a specific natural cause, and in the 6th case, the cause of death was unascertained, which meant natural causes, just not clear which one. And now we have 16 new medical experts who've been engaged by Lucy Letby's defense, all of whom have found no evidence of murder, no evidence of inflicted harm, no evidence of crime at all. It's not well understood, and maybe it never will be, but it's not well understood why the clinicians pointed the finger at Lucy Letby. I mean, there's 2 possibilities, obviously. One is that they genuinely believed that she was harming babies, or they were covering up suboptimal care, or worse. And indeed, that latter possibility is exactly what the defense were trying to argue at the trial. Of course, if the doctors genuinely believed that Lucy Letby was harming babies, then they should have called the police, and they didn't. And there's all sorts of question marks about why they didn't, particularly because the GMC, the General Medical Council guidelines, are incredibly clear that that's exactly what doctors should do if they think that their patients are being harmed. So what was and when I say the evidence here, I'm talking about the prosecution evidence. Well, there was 4 main types of evidence. I've amalgamated 2 of them into the last bullet point. The statistical evidence largely pertained to 2 things. One was the elevated mortality itself, and then the second thing was the roster chart. As for the medical evidence, of course, that was the prosecution assertion that there were these 25 incidents of inflicted harm using a variety of methods, which of course is unusual for a serial killer. But the methods invoked were injection of air into the baby's bloodstream, injection of air or milk down the nasogastric tube. In 2 cases, the prosecution alleged insulin poisoning, and there was also a couple of cases of physical attack. One accusation of smothering, one accusation of a physical attack on the baby's liver. In relation to the spike, the question, of course, is, well, what caused the spike? And the prosecution, of course, argued that it was Lucy Letby that caused the spike. And, of course, the defense said it wasn't Lucy Letby. Now, when the hospital became aware of the elevated mortality, it commissioned a report by the Royal College of Pediatrics and Child Health to look at this elevated mortality. And that was one of the documents that I dug up when I came across the case, and which persuaded me that she was innocent, because this service review was just a litany of issues and failings at the hospital. It cited suboptimal care, a higher number of admissions during this period of elevated mortality, greater levels of acuity, how unwell the babies were, lower gestational ages of birth, lower birth weights, multiplicity. 9 of the 17 babies on the indictment were either twins or triplets. Now, you're obviously going to have higher levels of multiplicity on a neonatal unit, but 9 out of 17 is incredibly high, and of course that is a significant risk factor. It's not quite clear why there were higher admissions on the unit at this time. It's thought that it could be related to closures of maternity units in North Wales. at the time, which would have meant that babies from North Wales ended up at the Countess of Chester, which would have been one of the closest neonatal units. But the Countess was actually a level 2 unit. It wasn't a unit that provided the care that was needed for particularly sick babies. So it's possible that babies from North Wales that should have ended up in a level 3 unit, such as Arrow Park, ended up at the Countess. Then, as far as the roster chart is concerned, as I said, this is based upon the prosecution medical opinion of harm when Lucy was on duty and no harm when she wasn't. So as far as the statistical evidence is concerned, the prosecution actually sought to underplay the role of statistics. They wanted to focus on what they considered to be strong medical evidence, but it did invoke very early on in the prosecution opening, it did invoke both the mortality data, the spike, and also the roster data. But I'm not going to spend too much time talking about the prosecution case. What I'd like to talk about is the police investigation that came obviously before the CPS got involved. And three aspects of that in particular: the engagement, or rather the lack of engagement, of a proper medical statistician, the credentials and selection of the medical investigator that they did use, and the process, the investigation process that was employed by the medical investigator, that so much evidence that investigation was biased. So just quickly on the prosecution case, there was no direct evidence. There was no strong evidence. Obviously, if there had been, the trial would have been over very quickly, instead of which it lasted 10 months, one of the longest criminal trials in British history. Lucy Letby was never caught in the act. You might find that surprising in a busy hospital. There were 2 blood test results that the prosecution argued were evidence of insulin poisoning. And those were the closest thing that they had to forensic trace evidence. But jurors never heard that antibodies can interfere with these tests and produce similar results. And then Lucy Letby herself, under police questioning, was presented with these test results and told, this is evidence of intentional poisoning, to which she replied, well, okay, but it wasn't me. Perhaps naively, but nonetheless, that was used against her at the trial. These 2 blood tests and insulin cases were absolutely integral, because they were the first 2 cases on which jurors reached guilty verdicts, and the judge had directed jurors that if they found her guilty on one count, they could use that decision to inform decisions in relation to the other babies, and she ended up being convicted on 14 counts. As I said, the statistics were invoked by the prosecution in its opening 4 paragraphs, but in the second paragraph, it also noted that the consultant's concern had been that babies who were dying had deteriorated unexpectedly. Of course, the question is, how is unexpectedly defined? Now, you put that in the context of the fact that there were only 2 consultant ward rounds a week, compared with an expected standard of 2 per day. None of the 7 consultants were neonatologists. They were all pediatricians. And the theme throughout the prosecution case was that these deaths and collapses were unexplained. They were unexpected because the babies were well. The babies were stable. Now, these 16 new experts, medical experts, have all found that the babies were not well. And of course, that's why they were in the intensive care ward on a neonatal unit. The babies were not stable. So not only were the deaths explainable, and these 16 experts have explained all of these deaths, all of these collapses that were on the indictment, but they should have been expected. So whether something is expected is of course entirely subjective. And I suppose, as somebody said to me, if you're asleep at the wheel, then everything is unexpected. Now, as you'll see in a moment, the police didn't get off to a great start with the investigation in terms of who it engaged as a medical investigator. But in 2018, it did try to do the right thing by engaging a proper medical statistician, who I think many of you will know, Professor Jane Hutton. And she gave the police some advice about what data was needed in order to do a correct statistical analysis of the case. She never got that data. And 3 years later, in 2021, the police told Hutton that, and I quote, "The prosecutor does not agree with our line of inquiry and has instructed us not to pursue this avenue any further at present." Now, that's quite shocking, of course, because while the CPS is able to advise the police on whether they think there's enough evidence, they're not allowed to instruct the police not to pursue a line of inquiry. And needless to say, this line of inquiry was never pursued. So that's Jane Hutton. What about the actual medical investigator who was engaged by the police? Well, Dr. Dewi Evans joined police investigation as lead medical investigator in July 2017. He'd been retired from clinical work for 8 years. He'd been a pediatrician, not a neonatologist, a very important distinction. Upon retiring from clinical work in 2009, he set up his own medico-legal consultancy, acting as a medical expert witness in many cases, mostly in the family courts where there are strict reporting restrictions. He prided himself on, and I quote, "never having lost a case," which of course is rather surprising given that the duty of an expert is to the court rather than to whichever counsel has engaged them. So how did he get involved in the case? Well, in May 2017, he sent an email to his contact at the National Crime Agency saying that he'd read about the case, he'd read about the high death rate, that it sounded like his kind of case, and that if Cheshire Police had no one else, he'd be interested to help. Now, at the trial, the defense tried to argue that this was touting for business, which I think you'd all agree it clearly was, and that Evans' testimony should be dismissed, but that was unsuccessful. The judge allowed Evans to continue testifying and argued that, it was up to the jurors to decide whether they felt he was credible or not. So it's the National Crime Agency that helps provide police forces with expert witnesses, or rather experts, when they need them. And often, as you'd expect, there's a careful selection process. However, in this case, the NCA just simply passed Evans to Cheshire Police unvetted and without there having been any sort of proper tender process. Now, since the trial, Evans he's changed his mind about how some of the babies died. And he's also sent a revised medical report about one of the babies to Cheshire Police, although Cheshire Police has refused to share that new report with Lucy's defence team. I just finally mention this horrific conflict of interest whereby an expert can, during the police investigation, diagnose inflicted harm in the knowledge that they're going to be engaged and paid by the Crown Prosecution Service as an expert medical witness. It's a conflict that the system allows, but it's certainly something that needs to be addressed. In fact, there was a 2011 report by the Law Commission which set out a whole lot of recommendations in relation to experts, and none of the recommendations were adopted. So, there are all sorts of issues with how Evans' medical investigation ensued, all sorts of evidence of lack of objectivity, bias. He did rightly tell the police wrote to the police telling them that if there was an identifiable clinical cause, it was unlikely one would be able to distinguish that clinical event from a potentially suspicious one, but then went on to find that there were no identifiable clinical causes, which is surprising given that there are so many doctors, whether the original pathologists, these 16 new experts who have found identifiable clinical causes. Evans, early on in the case, received from the police a summary of the case, which actually referred to a nurse being the subject of its inquiry. On the 20th September, he wrote to Cheshire Police saying that they were going to clarify, and I quote, who was there, doctors and nurses at the time, and also in which nursery. So this is clear bias, information that absolutely would have biased his investigation. And actually that contradicts his public statements that he conducted his investigation in a blind fashion. What were his instructions? Well, his instructions were to appraise the cases of 28 babies, but these cases had been selected by the clinicians themselves, who were the accusers of Lucy Letby. So that seems to be an appalling breach of process. Surely Evans would have wanted to ask for the details of all of the admissions onto the unit during this time and indeed outside that period. But being given cases that were selected by the very people who were accusing Lucy Letby is clear evidence of bias. Anyway, he was asked to opine on whether he thought these cases were suspicious or not. And at a meeting in October, he presented his opinions. 11, he said, were suspicious. 5, he thought might be. And 12, he said, weren't. In the case of 16 cases where he had suspicions, he referred to specific times of clinical events that he thought were suspicious. Now, this document that essentially contained the notes where we set out these opinions, that document was leaked to David Rose, who's the investigations editor at Unheard magazine, and he wanted to know whether Lucy Letby had been present at these suspicious events. Unfortunately, to do that, he needed Lucy Letby's full shift calendar, which he didn't have. Fortunately, I was able to give it to him. Now, how did I have it? Well, because Dr. Evans had emailed it to me. He'd been sent it, goodness knows by whom, and had done his own statistical analysis, and he wanted to run that analysis past me. Now, I passed this shift calendar to David Rose, and he found that Lucy Letby had not actually been on duty for 10 of these 28 suspicious incidents that Evans had pointed to. And on the back of that, he produced a roster chart. Now, this is not the actual roster chart shown to jurors. This is a hypothetical, if you like, roster chart that was produced based upon Evans' opinions expressed in October 2017. And you'll see there are 10 empty boxes. I suppose it's somewhat ironic that David Rose was able to write an article discrediting Evans, but where Evans had provided him with the document needed for him to write that article. Now, as I said, there are 10 events where Lucy Letby was not present, but the reality of medical diagnosis is that it's not easy. It's not like DNA or a knife in the back, which is pretty incontrovertible. Medicine is grey, and medical diagnosis lacks repeatability, which of course is a requirement of science, and indeed why statistician John O'Quigley called this roster chart that you'll see in a minute, that was eventually shown to jurors, a scientific fake. Anyway, so these 10, Lucy Letby wasn't present, so the police started looking for another serial killer, right? Wrong. The 10 events were forgotten, leaving this chart, which was weak, for a number of reasons, whether because the police may have felt there simply weren't enough suspicious incidents, or because the medical evidence behind these was not strong. Fortunately, then Ravi Jayaram suddenly had an amazing recall and remembered walking in on Lucy Letby murdering a baby. And then another of the accusing doctors, Dr. Breary, uncovered the two aforementioned insulin test results. And then Dr. Evans uncovered another 8 suspicious incidents. So in no time, the chart was looking good again. There's one empty box there, which is baby K murder charge, which happened at another hospital. So that was removed. And this is the chart shown to jurors, with an uninterrupted line of 25 X's. And I think you'll agree this must have been very convincing for jurors. The CPS did release a revised chart after the retrial. I won't go into details about what the changes were. And then there were a number of other anomalies that were uncovered either during the trial or after. And again, I can touch on these during the Q&A perhaps, but I won't go into them now. But what Lucy Letby herself? Well, she was very hardworking, well liked. She had an intensive care qualification, so she was more likely to be caring for sicker babies. But even adjusting for that, she was still very unlucky. But of course, in these cases, it's a given that the accused is unlucky, because if they're not unlucky, they're never going to get accused. So just to finish off, saying that, of course, Lucy Letby is at the center of this case, but it's about so much more than her. It's about trying to reform the health and justice systems that allowed this tragedy to happen, as well as many others, whether previous cases of miscarriage of justice, wrongful conviction of caregivers, or indeed the many NHS scandals that we've had. So thank you very much indeed. Questions? Essentially because there simply wasn't time. I did actually put that on the slide. That was part of the physical and digital evidence. And I made a distinction between these handover notes, these post-it notes, which the prosecution argued were confession notes, the digital evidence, these photographs of condolence cards. I made a distinction between that evidence and the statistical evidence, the roster chart and the evidence of the spike. So it's trying to make a distinction between the statistical evidence and the evidence that you mentioned. Yes, I mean, the judges don't like statistics being presented in their courtrooms. They think that jurors, probably rightly, that jurors aren't going to understand them. They're probably not going to understand statistics themselves. So the reality is that the proper statistics don't tend to get presented at trials, and instead you get constructs like the roster chart produced, which is as I've called it, a statistical abomination. I mean, that's the lottery fallacy, isn't it? So what the prosecution are saying is that, this is such an unlikely event that she must be a serial killer. Whereas, of course, what they should be, that's like saying, go and prosecute the lottery winner for cheating. Whereas, in fact, what should be taken account of is the fact that the probability of someone winning the lottery is 100%. Yeah. I mean, it's an interesting case to mention that, because the probability that was mentioned by the prosecution, the pediatrician Roy Meadow, was a probability of 1 in 73 million. And that was adjusted down upwards, as in more likely because of genetic and gender factors. But that's a bit of a red herring. The main issue, as you point to, is the fact that there are so many mothers around the country with two boys.